Bom dia a todos. Esse é mais um evento organizado pelo Ibradim em conjunto com o CORE-BR e com o CNR e ENOR, um webinar internacional sobre centralização dos registros na perspectiva comparada. Esse evento está sendo transmitido simultaneamente em 2 canais do YouTube. Um canal vai ter o áudio original em inglês, o evento será transmitido em inglês, e o outro canal terá o áudio com tradução simultânea para português. Então, eu vou passar a falar inglês e vocês podem acompanhar, seja no áudio original, seja no outro link que foi disponibilizado com o áudio com tradução simultânea. So, good morning to everyone. This is a webinar organized by Ibradim together with CORE-BR and CNR and ENOR. We have here our 4 international guests, also a special guest today, who is the Secretary Gianluca Lorenzon. He's the Secretary for Competition Advocacy and Competitiveness with the Ministry of Economy. He's going to give us our opening remarks. We also have here as moderators with me, I'm Fabio Silva, I'm President of the Committee for Security Interests and Credit of Ibradim. We also have Robson Alvarenga, who is the President of the Institute for Registry of Titles and Documents of São Paulo, and we have Patricia Ferraz, who is Institutional Director of the Real Estate Registrars Association, CORE-BR. We have in the up screen, in the top left, Professor Alejandro Garro from Columbia University, New York. We also have Professor Giuliano Castellano, directly from Hong Kong University, professor from Hong Kong University. We have Professor Ignacio Tirado, who's the Secretary General of Unidroit from Rome. And we have in the top right corner, Gavin Mcconsker, who's the Deputy CEO of the Personal Property Securities Registry of Australia. I would like to thank very much our international guests. It's a bit early in New York right now, 17 past 8 a.m. and already a bit late in Hong Kong, a bit past 8 p.m. and especially in Canberra, Australia, it's already past 11 p.m. So thank you very much, all our guests, for being here with us this morning in Brazil. I will just pass the floor directly to Secretary Gianluca Lorenzon for his opening remarks, thanking him again for being present here with us today.
To everyone in the panel. First, let me start by congratulating Ibradim, the whole institute, and everyone here for bringing this conversation to Brazil. The importance of this for us is remarkable, especially for us in government right now. I'll give you a very brief analysis of why this is so important for us very shortly. But just to start, today is a federal holiday for all public workers in Brazil. So even though it's a federal holiday, we're still working here because we have just so much work to do before the end of the year. This happens because most of the pandemic has postponed our major works and our deliveries for this year, but there's only so much you can postpone and so much we can accept to go over the next year. We're in the middle of the biggest reforms, as we call, since the Plano Real, since the 1994 currency and monetary reform that completely eliminated hyperinflation in Brazil. So why is the registry of securities and overall this kind of initiative so important for us? When we look at international indexes, such as the Global Comparative Index, the Doing Business by the World Bank, and so on, we'll quickly discover that Brazil has a serious problems when it comes to our whole landmark legislations that reflects in our environment for doing business. So what we are looking in here is how can we improve it and how can we do it in a way that it connects with the challenges and it connects with the different traditions, and at the same time with the different practices in our country, which is very unique when it comes to some of our jurisdiction practices. So one thing that's really clear for us is that we need to improve, and we need to improve sometimes not by innovating completely, but especially we need to improve by embracing the best practices, the benchmarks that prove to be successfully around the world, that prove to be successful. So one thing that's very clear for us is that we need to do that. And when we took a look especially at some two very important indexes, they tell us a very bad picture about Brazil. When we take a look at the product market regulation by the OCDE, what we see here is that Brazil has probably, with Argentina, the two last positions on the ranking, which shows that the quality of our regulations towards competition, towards transparency, towards institutional values is very low, which concerns us a lot. And when we look specifically to the topic of burden of regulation in the Global Competitiveness Index, we are in the last position among 141 countries. So that's very concerning. We have to change what we understand as a regulation, especially when it comes to credit, securities, and other financial issues regarding the law. So if we look specifically to the credit rankings and so on, our positions are also not much better. So we have a lot of work to do. We have a population that wants to enjoy the benefits that comes when you have a secure system to register securities, when we have a system in which we can have reliability on the transactions, and to ensure that all tangible and intangible goods that comes with different contracts for credit and capital, they're going to be respected and executed within the law. So all of those issues are very important for us, and so I congratulate you, Brazil, for bringing this conversation for us, because we want to move forward with this, and we are working to move forward with this. I think we're gonna have a nice announcement in the next couple of weeks, so we can have more interaction and more public discussion about how can we improve our legal system on these issues and on those matters so far. So thank you, Fabio, for this opportunity for me to say those brief words before this important conversation starts. I congratulate each and every one of everyone in the panel. We have 4 distinct professors in here from all around the world, since Columbia University to Hong Kong. So we're crossing the world here to Australia, to Madrid. So we're crossing the world here and having different perspectives and also a Brazilian legal experience. Thank you so much, Fabio, for the invitation.
Thanks very much. Thank you, Mr. Secretary, for those very encouraging words. And indeed, I agree that we need to move forward in that subject. And we're starting with the right foot here, with some very good, actually remarkable professionals helping us to start this path forward. I would like also to pass the floor to Patricia Ferraz, who is the Institutional Director of the Real Estate Registrars Association, for a brief explanation of the Brazilian scenario before we move on with our guests. So, Patricia.
Thank you very much, Fabio, for letting us to be here this morning with such an expert in guarantees and registry systems of movable guarantees. As I was according to you yesterday, I'm going to speak in Portuguese, so our audience that are Portuguese speakers will understand better what I'm going to say. I want to thank all the professors, the masters, for being here with us this morning and to give us some information, very useful information about their systems work in other countries. And I will start speaking in Portuguese. Conforme o Gianluca iniciou a sua fala, fez esse briefing a respeito da posição do Brasil no relatório do InBusiness, nós, registradores de imóveis, também estamos muito preocupados com esse cenário e temos trabalhado com muito afinco para melhorar o nosso sistema registral imobiliário. E, por conta de demandas de agentes governamentais, também estamos trabalhando em conjunto com registradores de títulos e documentos para que também esse sistema possa ser mais eficiente ainda e garantir uma publicidade mais eficiente dos direitos de garantias sobre bens imóveis. No Brasil, nós temos aqui uma população de 212 milhões de pessoas, somos todos nós falamos a mesma língua e somos o 5º país em extensão territorial no planeta. As nossas principais atividades econômicas são, de acordo com o levantamento de 2009, nessa ordem: serviços, indústria, comércio e agricultura. Ali compreendida na agricultura, a atividade de agricultura mesmo e pecuária. Nós tivemos em 2019, em dezembro de 2019, um pico de concessão nominal de crédito da ordem de 406 bilhões de dólares. Mas, diferentemente de outros países, nós temos no Brasil um sistema jurídico de distribuição de competências que compreende um Congresso Nacional, composto por deputados e senadores, 26 estados e um Distrito Federal que também produzem normas locais e, como eu disse, 26 estados e um Distrito Federal. Nós temos uma legislação grande, variada e espalhada, nós não temos todos os atos relacionados aos direitos reais de garantias mobiliárias em um só dispositivo legal. São vários deles, assim como as leis que tratam dos direitos reais de garantias imobiliárias. As garantias, tanto mobiliárias quanto imobiliárias, ficam a cargo dos registros de imóveis e dos registros de títulos e documentos. Nós temos cerca de 3.300 unidades registrais imobiliárias no país e outras tantas de registros de títulos e documentos. Dessas unidades, 3.000 concentram não somente a atividade registral imobiliária, mas também a atividade de registro de títulos. E todas as nossas transações são baseadas, portanto, na lei civil. A Constituição Federal brasileira criou uma exceção ao desempenho de funções públicas. Eu me refiro aí ao desempenho da função registral. Pelo artigo 236 da nossa Constituição Federal, quem desempenha a função registral são pessoas particulares aprovadas em concursos que são desenvolvidos pelo Poder Judiciário. E essas pessoas administram e tocam os registros de imóveis, os registros de títulos e documentos, por exemplo, sob uma gestão privada e sob fiscalização do Congresso Nacional. No que diz respeito à lei civil, que regula, portanto, toda a construção sobre os direitos reais e também os direitos reais de garantia, empodera o Congresso Nacional para editar leis de âmbito federal a respeito desses assuntos e também sobre o sistema registral. O sistema de registro de imóveis no Brasil, ele atua de acordo com alguns princípios, não é? Algumas regras de segurança jurídica. Nós não somos, no registro de imóveis, um registro de títulos. São atividades completamente diferentes, embora, como eu disse, na maior parte das cidades brasileiras nós tenhamos a mesma pessoa desempenhando as duas funções, de registro de imóveis e de registro de títulos. Dentre esses princípios, aqui para uma abordagem assim, muito sintética e inicial, nós trabalhamos a partir do princípio da legalidade. Nós só fazemos, portanto, aquilo que a lei nos permite que seja feito. Nossos atos são dotados de presunção de veracidade e nós temos raríssimos casos de anulação de atos registrais por falha registral. E trabalhamos, como eu já disse também, sob gestão privada, com fiscalização do Poder Judiciário e com uma fortíssima responsabilidade civil e pessoal de cada um dos registradores. Não existe indicação para desempenho da função registral por qualquer agente governamental, seja ele o presidente da República, o procurador-geral ou o presidente do Supremo Tribunal Federal. Os concursos são feitos pelo Poder Judiciário e as pessoas que são aprovadas nesse concurso público e alcançam as melhores colocações vão escolhendo os registros na ordem da sua colocação. Bom, tecnicamente, além disso, a atividade registral no Brasil ela é totalmente remunerada pelo que os usuários dos sistemas pagam pelos atos que são praticados, de modo que o governo, o Estado, não precisa investir qualquer valor para o desempenho, manutenção e aperfeiçoamento do sistema registral. Diferentemente do registro de títulos, que é um sistema que tem muitas vezes um cunho mais arrecadatório ou simplesmente de coletar documentos e expô-los em uma base, sem fazer qualquer análise jurídica a respeito daquelas informações que são colocadas dentro do sistema de registro, o registro de imóveis ele tem como principal característica a qualificação, a análise ex ante, inicial do documento, anterior àquele documento e aquele direito ingressar na base registral. O nosso sistema tem, portanto, um caráter constitutivo e somente os direitos que estão ali registrados é que têm a possibilidade e o poder de produzir efeitos erga omnes. Essa análise jurídica anterior ao ingresso dos títulos no registro de imóveis é extremamente importante porque ela proporciona a depuração das imperfeições dos títulos e às vezes inclusive dos negócios, produzindo um grau de segurança extremamente elevado no que diz respeito aos direitos de propriedade imobiliária. Não só a propriedade em si, mas também aos direitos de garantia que podem ser constituídos a partir da segurança proporcionada e pela publicidade proporcionada pelos direitos publicados no registro de imóveis. Além disso, todos os atos que são relacionados aos imóveis, em regra, devem estar na base registral imobiliária. E o acesso a essas informações se dá inicialmente pela emissão de certidões, que são solicitadas pelos interessados, sem a necessidade de identificação ou de explicitação do motivo pelo qual eles buscam essa certidão, e também em alguns estados, no estado de São Paulo, essa publicidade também é dada por meio da visualização online da matrícula dos imóveis. A matrícula é um documento que nós temos nos registros, que concentra todas as informações em ordem cronológica a respeito da situação jurídica do próprio imóvel e dos titulares dos direitos ali inscritos. De modo que uma certidão do registro de imóveis tem o condão de proporcionar uma informação rápida, com um custo baixo, altamente segura sem a necessidade de que se busquem outros agentes para interpretar aquilo que consta do registro. Além disso, nós temos a possibilidade de fazer no próprio registro de imóveis retificações de atos para aperfeiçoamento da descrição dos imóveis, correção de eventuais erros de registro que sejam praticados e que não afetem terceiros. E essas retificações podem ser feitas dentro do registro de imóveis. As decisões denegatórias de registro são passíveis de um recurso administrativo, que se chama dúvida registral, que permite não só a reanálise da decisão negativa de ingresso de um título no sistema registral pelo próprio registrador, e em caso de manutenção dessa decisão, este recurso administrativo pode ir para o Poder Judiciário, que vai também administrativamente decidir se aquele título vai ser registrado ou não, se aquele direito vai ser constituído ou não. E nesse caso, de uma decisão favorável do Judiciário a respeito do registro desse direito, desse documento que aporta no registro, a responsabilidade por esse ato deixa de ser do registrador. Por outro lado, a anulação de atos registrais só pode ser feita mediante um processo judicial. O funcionamento do sistema do registro de títulos, eu vou deixar para o meu colega Robson, mas eu gostaria de voltar só um pouquinho para falar que as unidades registrais são todas autônomas. Nós temos regulamentos judiciários estaduais e, às vezes, inclusive municipais, por conta de provimentos que são, para facilitar a tradução, regulamentos que são editados por juízes locais. E nós ainda padecemos da falta de um protocolo unificado nacional para o registro de imóveis. Nós temos o acesso unificado nacional para o registro de títulos, como o Robson vai falar, e nós temos ainda uma publicidade um pouco reduzida por conta da falta de um acesso único aos registros que constam nas bases de todos esses 3.300 registros de imóveis. É óbvio que é possível você acessar cada um deles e obter certidões de matrículas, mas um acesso unificado a todas as 27 unidades da federação, nós ainda não temos. É algo no qual nós estamos trabalhando, inclusive junto com o governo federal. Nós padecemos de uma falta de padronização na aplicação de leis federais e de alguns procedimentos registrais. Temos uma variedade de custos, porque as tabelas, os valores dos registros são fixados por leis estaduais. E dentro de todo esse cenário que eu descrevi assim muito sinteticamente, nós já desenvolvemos várias ferramentas que podem ser utilizadas em âmbito nacional. Por conta desses aprimoramentos, né, que são evidentes, que são necessários de serem feitos no nosso sistema, nós temos trabalhado com o governo federal, com o Banco Central e com as entidades de registradores do Brasil, para a implementação de uma reforma da Lei de Registros Públicos, que afeta tremendamente a atividade registral imobiliária. E com essa reforma, o que nós procuramos? Uma maior sinergia no sistema registral, com sistemas corporativos e com os sistemas públicos, como, por exemplo, a Secretaria de Patrimônio da União, a redução de prazos e procedimentos e a operação do sistema registral imobiliário por meio da coordenação de um operador nacional do registro, mantidas as unidades registrais já existentes. Dentro desta proposta e de acordo com projetos que nós já estamos implementando, nós prevemos uma um sistema, um serviço de atendimento eletrônico compartilhado de âmbito nacional, que inclusive já foi regulamentado pelo Conselho Nacional de Justiça, um protocolo unificado nacional eletrônico, um sistema interoperável e a recepção eletrônica de documentos com dados estruturados, inclusive no que diz respeito a garantias mobiliárias, com a utilização do protocolo MAC da Convenção da Cidade do Cabo. Além disso, nós prevemos a disponibilização de formulários para utilização pelos usuários, né, em casos de usuários eventuais, porque a forma de comunicação entre os registros e os sistemas corporativos, na nossa compreensão, devem ser feitos por meio de APIs ou tecnologia equivalente. E a partir do momento em que nós recebamos documentos eletrônicos com dados estruturados, nós vamos ter também a possibilidade de responder com certidões eletrônicas com dados estruturados. Mas, especialmente, a razão de nós estarmos aqui hoje e termos apoiado o Fábio na construção desse encontro, que é, para nós, assim, espetacular, é a necessidade de nós termos uma conversa entre os sistemas registrais mais detida e de incrementar o grau de publicidade da atividade registral imobiliária. Isso por meio de uma ferramenta, né, que nós chamamos SERG, Consulta Eletrônica de Restrições e Garantias, e que permitiria digamos assim, um upgrade no grau de publicidade registral. Hoje é possível nós fazermos em mais de 20 estados e Distrito Federal a pesquisa de bens, por meio de um número do contribuinte de impostos federais. Sejam pessoas físicas ou pessoas jurídicas, pessoas naturais ou pessoas jurídicas. E essa pesquisa, ela permite a identificação do bem, mas para você interpretar, verificar se existem restrições ou garantias já relacionadas a esse bem imóvel dessa pessoa, você precisa fazer efetivamente uma análise dessa matrícula. E uma das nossas propostas, que consta inclusive do Estatuto do Operador Nacional do Registro, é a possibilidade de que nós incrementemos o grau de publicidade, disponibilizando à sociedade uma consulta eletrônica exclusivamente sobre as restrições e garantias relacionadas a determinadas pessoas naturais ou pessoas jurídicas. E por isso, né, como nós estamos falando de recepção de documentos eletrônicos com dados estruturados, incremento do grau de publicidade, em utilização de ferramentas eletrônicas, em maior sinergia com os stakeholders, nos pareceu extremamente pertinente que nós pudéssemos conversar com o Giuliano, o Gavin, o Alexandre e o Ignacio, para nós entendermos, né, o que acontece em outros sistemas. E nós não estamos hoje aqui falando de garantias imobiliárias, nós estamos falando de garantias mobiliárias, mas na expectativa de que nós tenhamos contribuições ou elementos que possam eventualmente ser trazidos desses sistemas para incrementar o sistema de registro de imóveis, desde que nós tenhamos respeitadas, obviamente, a nossa cultura, né, brasileira, o nosso sistema institucional e preservada a segurança dos direitos reais de garantia e dos direitos de propriedade. Uma das razões pelas quais nós estamos interessados em ouvi-los enormemente é porque, inclusive, o sistema australiano foi já referido a nós como um parâmetro a ser observado. Então, eu agradeço mais uma vez ao Fábio, a organização magistral desse evento e a presença dos nossos convidados aqui, que estão aí cada um em um local do mundo, e eu tenho certeza que nós vamos sair deste encontro com ideias ótimas para serem implementadas não só no registro de imóveis brasileiro, mas também no registro de títulos e documentos. Obrigada, Fábio.
Obrigado, Patrícia. Thanks very much to Patrícia for her intervention. And I would like to already pass the floor to our next speech. I'll let Robson do a very brief good morning to everyone, and then we will start with the presentation of Gavin Mcconsker, as we're already a bit late on the schedule. So thanks very much again for everyone. There were some very good, remarkable opening words, and I think that helps us set the information level for everyone. So Robson, I will let you start speaking, and then we will just pass the floor to Gavin. Thank you very much.
Well, it's an immense satisfaction to participate in this panel with specialists from other countries to discuss registry of guarantees, which is a topic important and universal because it's an essential tool for each and every economy in the world. I would like to take the opportunity to send a quick message to all legal professionals. Technology is our ally. Don't be afraid of technology. Paper was never part of the essence of the contracts, serving only as means of proof. And it's worth mentioning that paper has always been imperfect in several aspects. For many years now, digital technology has been fully capable of replacing paper, adding a much higher level of security and precision. The intervention of a registry officer, according to the legal rules of each country, has always represented and will continue to represent a fundamental element of reliability and security for the authenticity, publicity, and effectiveness of legal affairs. We all know that technology brings its complexities and its flaws. Only through a registration system it will be possible to equalize technology and legal security in a permanent and impartial way. It's essential that all registrars get used to the idea that they must increasingly specialize in understanding and applying new technologies to ensure the effectiveness of registration and the security of legal business. The integration of all information about contracts and guarantees, not only nationally but also internationally, is an undeniable need and a challenge that needs to be overcome jointly by the nation. And for that, the support of international jurists and specialists will be essential. In Brazil, the competence to register guarantees is divided in two specialties. One takes care of guarantee state, and the others deal with other assets and rights. But we are preparing a major national portal to unify access to registration information over the internet in order to allow full access to all the market. Thank you very much, and I hope you will enjoy the rare opportunity to hear from our guests that are very wise professors.
Thank you very much, Robson, and I will just like to pass the floor directly to Gavin, our first guest, for his presentation. Thanks.
Thank you, Fabio, and thank you to the kind introduction that you've provided. It's a pleasure and a privilege to be able to speak to you all today and to describe some of the Australian experience and touch on a little bit of the benefits of the reform that we have seen in our country. And I can also touch on some experiences from some additional work that I have been able to and fortunate to undertake in the international sphere. So my name is Gavin Mcconsker. I am the Deputy Chief Executive of the Australian Financial Security Authority. And in Australia, we look after the personal property securities regime, which is the Garantias Mobiliares regime for Australia. And we also look after the bankruptcy regime for Australia as well. And if it's possible, I'm not sure if the slides are showing on the screen right now. Great, there we go. Thank you so much for that. Thank you. So I would like to, again, thank you for the introduction and to be able to speak with you today. First of all, I thought I would set the scene a little in respect of the Australian legal system and the reform within the Australian context that was undertaken. So Australia, we have a population of around 25 million people. We are the 6th largest country by earth mass in the world, and we have around 2 million active trading businesses. There's obviously in Australia, as with your country and elsewhere, a significant amount of finance that certainly enables the country. But one of the key points of commonality that Brazil has with Australia, albeit Australia is very small in number of states and territories, is that we are a constitutional federation, just like Brazil. And the complexities in undertaking such a reform with even the small number of states and territories that Australia has cannot be understated. So we are certainly aware of a range of the challenges that you will face in Brazil as you move forward with undertaking the reform of this nature. Of course, under a constitution, the constitution defines the powers which exist and the delineation of those powers between the states and the territories. So before we move into the more description about the benefits of the reform, I just wanted to set a little bit of the scene as to the situation before we undertook the reform in Australia. It was a very, very complex mix of legal frameworks and security interest registrations across the state and Commonwealth level, where there were around 70 different laws which related to security interests in personal property. Some of this legislation was overlapping, and there was a lot of duplication and uncertainty in the market. And there was certainly a range of gaps as well. There are also many registers where it depended upon which jurisdiction you were operating within, the type of interest that you wanted to register, the class of debtor. For example, there was a separate register for charges of corporate debtors, and other security interests were required to be registered on different registries again. The different type of property might have a different registry for security interests, one example being motor vehicles, the location of the property itself, and the type of transaction. So there was a range and a mash of complexity in the framework that existed prior to the reform in Australia. I suspect you may, that some of that may resonate with you in regards to the potential situation that you may be dealing with and looking to be able to overcome to provide a coordinated approach in your country as well. In addition to all of those things, as a common law jurisdiction, Australia also had a range of what you might call uncodified or unwritten rules and procedures. Under our constitution, there's limited powers to the Commonwealth, and the states can legislate for everything that is not limited, is not provided specifically for the Commonwealth under the Australian Constitution. And interestingly, there's no single head of power under our Constitution to be able to deal with personal property securities under the legal regime. So what that required was the coordination in a very strong way between the states, territories, and our Commonwealth government to be able to make this reform happen. A referral of powers to the Commonwealth from the states in regards to the relevant heads of power that were required to be able to make this law come to fruition. And that required a very significant level of partnership agreement, intergovernmental agreements, and things of that nature. So again, we can, in the short amount of time we have, I won't go into too much the detail, but it's something that I just wish to highlight as a range of complexities. But we finally were able to make it happen. And it came together in an Act of 2009, which commenced in 2012 in Australia. One of the key aims that was written into the explanatory memorandum provided in our Parliament at the tabling of the bill was to provide more certainty, improve consistency, and provide a simpler and cheaper arrangements for personal property securities in regards to the way that they are established. It was based on principles developed in a number of other overseas jurisdictions, of course, the UCC in the United States, and also the PPSA regimes in Canada and in New Zealand. It created our centralized national registry of security interests called the Personal Property Securities Register. And it also created the offices of the registrar and deputy registrar. One unique feature in our act that we undertook is actually to review the effectiveness of the policy and the regime only 3 years after the introduction. That review was completed and tabled in our Parliament back in 2015. And whilst a number of recommendations were made, through the review, the overarching sentiment from that review of the regime was that it was a very positive outcome for the economy. Now, one other point to make is that it's a reform for all economies. I'm fortunate to be able to support, and I'm a former World Bank Group staff member as well, and I continue to consult to support the World Bank in undertaking reforms in a range of developing countries. But this is a reform which is for all economies of the world. And the evidence of that is through the G20's adoption of an action plan for SME financing in 2015 under Turkey's presidency. Included within that, the reform number 2 on the screen there is around improving the ability to use movable assets as collateral. And specifically, a range of the indicators under the implementation framework for this reform are very aligned to the doing business indicators of the World Bank. So what's the experience been like in Australia? Well, since the launch in 2012, there's been over 22 million registrations completed on our registry. We have 10 million currently active registrations. And so that shows that there's a lot of activity that comes and goes onto the registry. In any given financial year, we have between 2 and 2.5 million new registrations created. And we have around 10 million searches of the registry. Now, some of the key factors that I look at in operating the registry are the number of amendments and discharges. I want to see high numbers here to show clearly that people are using the registry effectively, that they're maintaining their registrations, and therefore removing clutter from the registry so that it can be used as an effective tool throughout the economy, something that's very important. How our registry operates is that it is a direct entry by the creditor or secured party into the registry itself. There is no intermediated process. There's no formality involved in that process for the creditor to make those direct entries. It's also a notice-based registry where you are unable to, even if you wished to, you're unable to attach any documents. It provides the minimum set of information that's required to make it clear what the collateral is, and obviously the details relevant to the grantor, and obviously the secured party or the creditor. One important point to make, which is something that is a very useful consideration for your approach, is the timing of the effectiveness of the registration. In Australia, and I'll comment in a moment also on the Mozambican system, the registration becomes effective only once it's searchable on the central registry. And that's a very key point that I think is useful, in particular as you move towards an electronic system. Anybody can search the registry 24 hours a day, 7 days a week, and see what's listed. You don't have to create a log-on account. There's no proper purpose test to undertaking that search. We do have some privacy protections for individuals, where individuals are registered as grantor. But there's also a range of abilities to be able to do a search at any point in time for a small fee. So in terms of the design and the operating model of our system, there is a web user interface or a website, but we also have a direct API, application programming interface, or what we call business to government interface. And 80% of the transactions in our system are created via that channel. That's where, for example, the major banks, the major information brokers and aggregators and others create a direct link with our system and perform transactions themselves and help others perform transactions on the registry. We have a national service center, and we provide training and testing environments, electronic environments for users of the system to train their staff and undertake testing on the system. We also validate entries against a range of additional sources, to the company's register, the business register, to ensure that the details that are recorded in the registry are accurate based on, we don't choose those, but when you enter and make a filing on the registry, you can confirm that the company number that you entered, that the name of the company is as you expected. We also have a few value-added services where when you search against a motor vehicle, it will provide details from the policing databases as to whether the vehicle has been stolen and written off, as well if it's been in an accident. And also we have recently added things like safety recalls for motor vehicles, where the Takata airbag recall, which is a significant international issue that has arisen. Now, I just wanted to touch on, as I mentioned, the Mozambican experience, and this is something which I think is also potentially useful, for consideration in Brazil, but highlights the ability, and I know one of the interests is the maintenance of the competencies of the conservatories in place, and the system and the legal regime that's been adopted and passed by the Parliament of Mozambique is of a similar nature. It keeps the competencies within the registries that exist around the provinces in Mozambique, but creates the central registry of security interests. One of the key things I go back to is that the security interest becomes effective at the time that it's searchable on the central registry. So the procedures that exist before that need to be undertaken based on the competencies that exist in the system and in the legal regime. But the effectiveness of the registration occurs at the time that it's registered on the central registry electronically and becomes searchable. So what are some of the successful reform considerations here? The centralization is clearly key. That's a highly usable system, and that the cost of access is very minimal. Reducing the transaction cost is very important, where we consider that there's reducing the formalities to the extent possible to allow the direct entry as a part of that process is one of the key considerations there. Now, another success factor is how well used is the registry. One of the success factors that's defined by the International Finance Corporation best practice measures is that there should be between 3 and 6 searches for every single registration on the registry. In Australia, we have a ratio of around 4 to 1, though that's been increasing over the last couple of years. Now, why is that so? If you think about a lending transaction, and I'm a former banker as well with Citibank in a former life many years ago, you, as a part of the process, would want to search the registry at an early stage in the consideration of issuing finance, and then you want to search it again before you actually disperse the funds, and then finally at the point when you, after you disperse the funds, you want to make sure that the registration has been made on the registry as well. So that's an example of where there's a few searches that are conducted with a single registration. Moving on quickly, given the times, we undertake a lot of work to ensure that there's a high quality data on the registry. We are not responsible for entering data. We have no involvement in entering data, but we still monitor the registry to ensure that there is a high quality of data on the registry, and we take action where we deem it necessary using the powers of the registrar to be able to remove registrations where we see that that's appropriate to do so. And of course, there's an administrative and a judicial process to be able to amend the registrations on the registry to the point, if that's necessary to do so. So I'll skip quickly through some of these particular slides that touch on those aspects there. Some of the very important things that we find is that stakeholder engagement is a critical factor. I think the evidence by the group that you have already established to undertake this reform, the commitment clearly demonstrated by the government, as mentioned by the Secretary at the beginning of the opening remarks of this forum, is very clearly something that's very much on the radar. But stakeholder engagement is what will drive the success of the reform. We have spent a lot of time focusing on stakeholder engagement, and the point that you'll see here towards the bottom of this screen showing we have an ongoing registry enhancement program. The important factor is it's not a set and forget type of system. You must consider how the economy uses the regime, uses the registry, and actively have a program of enhancement to ensure that you can increase the transactional efficiency throughout the economy. We're very transparent in how we do this. We publish a list of enhancements on our website, which have come, most of the suggestions have come from industry themselves, and we tell them when we're going to make those enhancements, or if we cannot because of operational or cyber security reasons, we will tell them that we cannot make those enhancements, or if it's outside the legislative framework, for example. We undertake enhancements roughly every 6 months. Education and awareness, again, a very big factor in terms of the success, and that leads into some of the data points as well. So one of the things I did before this presentation was took a little bit of time to make sure I understood some of the economic context within Brazil. And what I find through the enterprise survey of the World Bank is that two of the key factors that that businesses have identified as the most significant challenges in Brazil are issues with regards to access to finance and issues with regards to the informal sector. So what I thought I would mention is that there are inclusions within this particular regime which support overcoming some of those challenges in certain ways. Sorry, I skipped a slide. So the first thing that I thought I would point out is that there's two types of credit. There's credit to businesses and there's credit to consumers. One important factor is that when you are dealing with small businesses, and in my country, I think it's probably similar in most countries, small businesses make up over 97% of businesses in Australia. It's often the case that it's difficult to identify where the credit is to be used, the finance is to be used in a business context or an individual context. And so this reform actually covers both, and it helps reduce information asymmetries by ensuring that the security interest is registrable over both the credit provided for business and the credit provided for consumer purposes. That helps in reducing the information asymmetries for creditors. And based on my own, again, experience as a former banker, globally, there are 5 C's of credit as a part of the credit decisioning process. The collateral and the conditions are the two which are particularly relevant for this type of reform. You need to understand what collateral you have to be able to take as a creditor when you are offering secured finance, and that improves the ability to provide risk-based pricing for that finance. In terms of the conditions, it's not only about the economic conditions, it's also about the legal and institutional framework. If you have a central registry of security interests in movable assets, it provides a significant improvement in the environment, not only for providing finance to small businesses, but also for investors, both domestic and foreign, to be able to support the take-up of project financing and other arrangements in your country. So some of the benefits of the reform that we've seen in Australia. Our econometric assessment indicates that our regime and our central registry supports around 1/4 of GDP by a conservative estimate. That's a significant finding. We've also found that in the first 5 years of the operation of our registry, that new businesses, which is a business less than 5 years old, was registered on the registry as receiving finance with an 800% increase. We started with only 2% of businesses registered on the registry receiving finance were new businesses, up to 16% in the first 5 years. That shows the support of a regime of this nature for entrepreneurship, and it's very significant. We have a lot of engagement with fintech and the enablement of the PPSR for fintech and alternate financing arrangements has been well regarded by the fintech community. Trade finance, where invoices are issued and payments made later, has been a very significant user of the registry. That's business-to-business finance that occurs. Obviously, it improves credit risk assessment and contract enforcement as well. Of course, we know that SMEs are the lifeblood of our economy, as I mentioned, and the lifeblood of SMEs is credit. This slide really just discusses that it's future-proofing an economy in that it can provide a centralized registry for all matters, all types of assets that are defined as personal property. And that's current and future types of assets as well. Okay, so I might just move on quickly given the time. And so again, we've received a range of comments from the industry about the benefits of the reform, about improving clarity and security. Our legal fraternity was also a very paper-based regime beforehand. Some of these comments are from the legal fraternity. There's significant benefits and improvements that they have seen through the introduction of the centralized register of security interest. Finally, my last slide is to be able to just talk about some of the benefits of the reform, also to the financial system. We work a lot across government with the Central Bank of Australia, called our Reserve Bank, our Department of Treasury, to be able to identify how the data in the registry can be used for best effect. There's significant financial stability benefits by strengthening the balance sheets of the financial sector by diversifying assets secured as collateral. And through that, there's also, through these current times, also been looking at signs for early contagion is one of the emerging factors for the use of the registry. And of course, particularly in a post-COVID world, the importance of the registry is well regarded in terms of supporting economic growth, a private sector-led recovery to come out of COVID. And one of the data points I drew from there is the percentage of private credit to GDP. Noting Brazil is at around that 63% mark, as at 2019 data from the World Bank IMF. Relatively comparable with the Latin American colleagues, whereas some of the OECD members are up around 144 in average. In Australia, we sit at around 136%. So thank you for your time. Apologies for going a couple of minutes over, but I'll end there and hand back to Fabio. Thank you so much.
Very much, Gavin. That was a very interesting explanation. We already have 6 questions to you that I'll send to you for our discussions part, but for now, I'll just pass the floor to Professor Ignacio Tirado, who will do his presentation. So please, Ignacio, you have the floor.
Can be uploaded as well. So thanks very much to Ibrahim and to Fabio for the kind invitation. It is a pleasure and an honor. I should say it is not even 1/10 the pleasure it would have been if we could actually have come to Brazil to do this this seminar in person, but I'm hopeful that in the future we will be able to, perhaps when the reform that is which is underway and which looks so excellent and is going to be a game changer, no doubt, for Brazil, we could all visit and do it in person. I think it is in order for me to say that Fabio is, Fabio Rocha Pinto e Silva. The Brazilians are the only people in the world that have more names than the Spaniards. Is that I've known him for many years, and he is a world-renowned expert on this topic, and someone who takes the name of Brazil very high up. So it is a pleasure to collaborate with you. The perspective, I am a Spaniard, but I am living and speaking from Rome because I am speaking on behalf of the International Institute for the Unification of Private Law. I don't know if you can see my presentation. Can you? Yes, all right. Very quickly, just to explain to those of you what UNIDROIT is, very quickly. This is an intergovernmental organization. It's almost 100 years old, and which has 63 member states, but which actually have over 90% of the global GDP and almost 75% of the world population. Among the countries that are our constituents, Brazil stands out, and therefore is one of our most important members. The reason why Fabio has invited UNIDROIT to participate is because we offer a different type of perspective, which in a way resembles very much the reform that's being designed in Brazil. And what I'm going to talk about is the existence of an international registry, which also can coordinate and does coordinate with local registries through a system of national point of entry or access. So what I'm going to talk about is also something which is relatively familiar, or should be, to many Brazilians, especially to the experts in the area, because Brazil is part of the Cape Town system. The whole idea of having a system of secure transactions over a certain type of equipment was that the statu quo, no matter how developed the system of secure transactions over movable assets was, and it usually wasn't very advanced in many countries. No matter, even if the countries had a good system, there are certain assets which are inherently so movable that the normal rules to determine applicable law to that security, which is the lex recite, doesn't work very well. Planes, trains, they keep moving from country to country, and therefore which law applies might be at a certain stage just pure luck or unluck. That undermines predictability and therefore lowers the amount of credit that is in the system, and the cost of that credit is higher than it should be. So because of to overcome that problem, and also to overcome the diversity of legal systems of securities over movable assets, it is that the Cape Town Convention was approved and implemented soon. It will be 20 years. The whole idea was then to offer an international regime to create these international interests over movable assets of high value, which are uniquely identifiable. And it has worked very well. It is one of the most successful international commercial treaties there is. Right now we count 82 countries, and only in the application of one of its protocols, which concerns aircraft and related assets, it was at the beginning of 2019 that there was already more than 1 million registrations. Therefore, it is very successful, and it is used for a good portion of the business done with aircrafts, with engines, and with helicopters. So the scope of this type of registry and of secure transaction system is actually very broad, and it is very much in line with what's regarded nowadays as best practice, as defined by the model law of Ancestral, and which looks very much like the reform which Brazil is about to implement. So congratulations on that front, because you're going to be at the cutting edge of secure transactions. The Cape Town Convention, at least the aircraft protocol, which is the one that's in force now, is one which applies to uniquely identifiable objects, and this is something we will talk about later, because it's one of the key issues and it's not an easy one in practice. And it concerns both security agreements, conditional sales, and leases. And thinking that a secure transaction is actually a lease is something which might sound a bit strange for civil law jurisdictions, but at this stage, I think everyone realizes that that is one of the main parts of this core business. At least for the aircraft industry, leases are the majority of these transactions, therefore are of high importance. We'll not go into the detail of the transactions because I think your interest is more focused on the registry itself. Obviously, the whole model is based on this international registry, and this international registry, what it does is an online device which works like a Swiss clock. It was mentioned before that we should not be afraid of technology. On the contrary, technology is the key to all of this. It's the key to a well-functioning system. It's a key to reducing costs. It's a key to minimizing the risk, almost to completely get rid of the risk of corruption. We've all heard in many jurisdictions the problems with speed money and things of the kind. None of these can happen in a system such as Cape Town or the one that Brazil is about to implement. The international Cape Town International Registry is a registry of interests of secure transactions, if you want to call it that, but it doesn't provide. It's not a registry of ownership, which is something which also might be different to certain civil law jurisdictions. It is another novelty, which is also part of the Brazilian project, is that it's notice-based, therefore is not based on documents that do not need to be sent to the registry for registration. That, of course, takes away a lot of delays and problems in practice. It serves its main purpose, which is to determine priority among secure creditors, and with the exception of non-consensual security interests, which might be determined or declared by each country. The rule on priority is one which will be very familiar to you, because it's prior tempore potior iure, first in time, first in right. And the registry only tells you that there could be security, a lease or a secure transaction there, not that it doesn't provide proof of it. So it just alerts the parties, but it does provide priority. The international registry, in the case of the aircraft protocol, as some of you will know, is run by a joint private public entity, which was initially supported by the Irish government, called Aviaretto, which is supervised by ICAO. It is acting fully as a registrar, this entity, Aviaretto, with unlimited liability. and it provides a number of very, very important services for the running of the registry. And these are elements where you might want to consider, because all of these items which I've selected here are functions of the registry that are key to the well functioning of the system. They are all very similar to Gavin Mcconskers presentation, what he said about the Australian and other systems, because they all pertain in the domain of best practices in terms of registries. So the registry provides, of course, a hotline help desk of 24/7. You can access by phone or email, and they can speak several languages. Although the vast majority of users of the registry, the vast majority use English. It provides the service of authorizing companies or individuals that want to have access to the registry, either to register or to search, which are the two main functions that are performed by the registry. It is also a system which, with the highest and most up-to-date technology, issues digital certificates for electronic signatures, and the whole system is designed in a way in such a way that the registrations cannot really be repudiated because of all the certainty that's provided for by the technology, and they cannot be altered because they use a very sophisticated cryptographic hash algorithm system, which provides for the super secure protection of the information included in the registry. The registry also issues search certificates, as I said before, which confirm registration. And if the search is one which is has the right form, the signed certificate issued by the registry should form electronic evidence and therefore should bear all the legal effects that such evidence should deploy in a court of justice if it's necessary. The international registry, however, does not provide legal advice. In fact, the people running the registry in Ireland very proudly say continuously that they don't hire any lawyers. So there are no lawyers really working in the registry in Dublin. Or if there are any, there are a minority, they're mostly engineers or economists working there. So no legal advice is provided. There is no advice also on whether the parties should register or not, although the answer to that is easy. If you want to create an international registry, you need to register. They don't mediate between the parties, and they don't assure, as I said before, anything concerning the actual deal which is being given notice of. The system works in a closed manner for registrations, closed meaning that you need to be authorized as an administrator or as a user of the system. That is not even necessary for the searching, which is open. You just need to provide your basically your email. And the parties that are part of the deal, which is registered, do need to consent. How do you set up the accounts and the searches? I'll just fly through this. The application is, of course, filed online, and the payment is also done online through credit card. This is very quick. And although if you look at the official documents of the website, it will say that in less than 24 hours, the documents will be received. It will be the application will be handled after the documents have been received. The truth is that the time is usually much less. It's quicker. It works, as I said before, as a Swiss watch, very, very precise. The register will search the identity of the applicant to access the information. It will search that the identified applicant actually acts on behalf of the entity and is authorized to do so. of course, checks also the existence of the entity and that the contact details are correct. These are the basic things that are checked. So as you can imagine, the whole thing is very basic and thorough, and there's no need for any in-detail review by a registrar, which is the usual ways of registries in a more classic system in civil law countries. There are three types of searches. The most important one, because it does provide the adequate information in case you need to use it, is the priority search. Then there are informational searches, which are free, that you don't need to pay for those. And then you can also search for the declarations that each state, which is party to the convention, has made, so you can actually know what would be the applicability of the Cape Town Convention to a specific country, because there are a number of, although the convention might apply to a country, there is a part of the legal regime which might be altered by the voluntary declaration of the states, and the registry provides you with that information free of charge as well. In case of priority search, certificate can be issued, and as I said before, it constitutes evidence, which is what you need in some cases. How to register? Very easy. You first decide or define how to do it. You have to supply some basic data concerning, because this is not by debtor grantor identifier, as opposed to other systems such as the one in the model law, which is you can search by asset or by grantor, but here this is an asset-based registry. What you have to do is provide the data of the asset you want to research, the equipment you want to research, by the data that has been provided by the manufacturer. So what you do is basically provide the serial number, the model, and other information provided by the manufacturer, which everyone should have when they want to register. You have to be very careful when entering the data, of course, because that can, any imprecise typing or inclusion will lead to misleading information. As I said before, there is a need for consent to the parties involved in the transaction, which is registered, and therefore you need to provide the consent of the parties always through a simple digital signature, which has been previously vetted by the registry, so this is no problem. You can register or you can amend an already existing registration, subordinate it, subrogate it, or even discharge it to the extent that the beneficiary consents to it. As Gavin Mcconsker mentioned before, this is the same here. The priority and the effects are linked with the searchability of the information. So once the information is entered, you want to make sure that you search for it and it appears, because only then you will get the priority. As I said before, the system is designed so that it is used directly by users, or the authorized users. The truth is that because Cape Town is implemented and has been implemented by countries which already had systems of secure transactions over movable assets and equipment, there is a natural tendency by some countries to want to keep the infrastructure that they already had in place. And when they join Cape Town, they make a declaration under Article 19 stating that determining a national entry point. That is the case of Brazil, that is the case of Spain, that is the case of a number of countries. What this basically means is that if that has been the choice of the country, you have to work the operation of the registry through this national entry point. There are two types of national entry points. You can have one, I mean, there can be one or more national entry points, but they can be authorizing. And therefore, you need to use that for, at least for the equipment, if that's determined as such by the country, for the equipment which it is registered in the state. In the case of aircrafts, it affects airframes and helicopters, but not engines, because engines don't have a nationality, so you can't make it mandatory for engines to be searched through this national entry point. The system is pretty simple. If it's mandatory and you have to run through it, what you do is you start the online process in the national entry point. You get a unique authorizing code, and with that you can proceed on to the registry. There is also the possibility to have a national entry point which is merely transmitting the information on to Dublin or to wherever the international registry is in other protocols, but that is less frequent. The truth is that this passage from one to the other does not necessarily add too much to the operability of the system. It doesn't really add certainty, because the national entry point will not be in a position to alter the basic tenets of the function of the system, and all it really does is delay slightly the process. But in any case, it is still well functioning and very well coordinated. So from the good coordination of the national entry point with the international registry, you can learn also perhaps as to how to connect this centralized registry that you have with the different registers that you're going to have around the country. So this is just another example where you might want to have a look because it works very well. Just one final point I wanted to make concerning the MAC protocol. The MAC protocol is the latest protocol. It relates to mining, agriculture, and construction equipment, and therefore the likelihood that this protocol will share common ground with the movable assets registry of a country exists in a much clearer sense than in the case of aircrafts and airline engines and helicopters. We are now it was a bit less than a year ago that we were in Pretoria in the diplomatic conference approving this. Gavin was representing Australia, and we had the opportunity to meet there as well. The diplomatic conference, amongst its different resolutions, included the setting up of a preparatory commission, which is taking all the steps necessary to ensure that a registry is set up for this MAC protocol, for this type of unique equipment in the mine, agriculture, and construction equipment. This registry, of course, will learn from the good things that the aircraft registry has, and it will follow closely the aircraft registry system. But we are going to have to adapt the registry to the different type of machinery and the different type of market. That is the process we are going through now. You have to think that MAC transactions have a much lower value usually than aircraft transactions, and therefore the fee of the registry will probably have to be lower. The users of the MAC registry will be way less sophisticated. Those holding a big bulldozer will probably be less sophisticated than those leasing an airplane. So that implies the introduction of smaller enterprises in the picture implies that the system needs to be made very user-friendly, even more than that for aircrafts. Then there are a number of problems because instead of having 4 or 5 major world manufacturers, as is the case of aircrafts, here we're talking about thousands of companies that produce MAC equipment, and therefore each of them, there is no uniform way to identify the equipment with serial numbers, and therefore we are working on ensuring a proper identification of the equipment so it can be properly registered and searched. But this goes out into the detail, and I don't want to bore you with that. I've already exceeded my time. So I thank you again, and I'm here for any doubts you might have.
Thank you very much, Ignacio. That was very, very informative. And thanks again for being here with us today and for your very kind words. I would like to now give the floor to Professor Giuliano Castellano from the Hong Kong University for his exposition. Thanks very much.
Thank you very much, Fabio, and thank you for organizing this wonderful event in international venue. Of course, I mean, I'm very honored to have such, fantastic audience, and of course to talk after such a fantastic speaker, and even more fantastic to come. So I will try to also to fit what is my area of expertise, and mostly how I am involved in the secure transaction law reforms in different jurisdictions, and as well my research in the area. So as Fabio was saying, I'm Giuliano Castellano. I'm associate professor at the University of Hong Kong and deputy director of the Asian Institute of International Financial Law. I'm also having the pleasure of working with international organizations, and I've been part of the Junte-se working group that has elaborated, among other things, the model law on secure transactions. That's also how I had the pleasure to meet Fabio and the other esteemed colleagues that are here tonight. After that, I start to actually to investigate a bit more the implementation of the model law or other, let's say, form of international standard on secure transactions. And I've been collaborating with the World Bank and with other organizations for the effective implementation. In particular, what I've been focusing on is the connection between prudential regulation and secure transaction law. Junte-se also elaborated a document that tackled this aspect, which is the practice guide on the model law on secure transaction, which has been actually released in 2019. And I want to share with you a bit of this experience that I had in different jurisdictions in implementing and coordinating secure transaction law with prudential regulatory standard. Notably, I'm referring to banking regulation, capital requirements, as well as provisioning requirements, provisioning allowances. What I will do is, also in the interest of time, I won't use any slides, so I will try to make to streamline my presentation, let's say, my sharing of experience. First, I will try to explain why this matter, why we need to talk about it, and giving some example of, say, good and bad practice. I'll try to highlight the good ones. And then also to focus on why it matters in the context of the registry, which is essentially the main topic of our conversation. So allow me to give you a brief introduction of what is these why it matters coordinating secure transaction law reforms with prudential regulation. Well, the first point, we can take it quite general, quite high from a policy level standpoint. We can say that prudential regulation is vastly aiming at promoting financial stability and the solvability of financial institutions, whereas the effort made in the sense of secure transactions and bolstering creditors' rights, together with insolvency and the certainty of information on different creditors, aim primarily at promoting access to credit and financial inclusion more broadly. So we have heard a number of virtuous initiatives that has been taken by different organizations like Junte-se, like Unidra, on favoring SME lending. So coordinating secure transaction law reforms with prudential regulatory framework is essentially meaning coordinating two fundamental policy goals, policy objectives, which are access to credit and financial stability. Now, this is quite strong both from a political standpoint and from a policy and more practical standpoint. First of all, especially in this time, especially in this current economic environment, we want to be very clear that stability and access to credit are not at odds. There is no trade-off. We need to pursue them at the same time. A liquid market is a stable market. A market that actually is lacking of sufficient credit, especially for SME, which, as we have just heard, as we know, the blood of any economy. So a market that does not provide sufficient liquidity to this sector is not a stable market, is not a stable financial system, more broadly. So going from this general and very high-level perspective, we can start to enter a bit more into the details. And so what we might realize that the implication of this coordination is going to affect the banking sector, the non-banking sector, and as well the establishment of sufficiently liquid secondary market for collateral, and for different forms of assets that can be used for to finance small and medium enterprises. The idea in this regard is that if we do not coordinate, not every asset, not every collateral is going to be considered from a regulatory perspective eligible to reduce capital requirements or simply actually to account for provisioning purposes. And there are, of course, from a prudential standpoint, there are good reasons for doing this, in a sense that some collateral needs to have a specific market. Some other collateral are very difficult to be evaluated, and therefore actually we might not be willing to grant a blank permission to essentially lower capital requirements and therefore actually be more safe on the stability side. However, if we have a modern secure transaction system and which is transparent and which is rooted on the establishment of a registry, we can actually much more easily assess and allow simply the creditor to decide and to run a number of analyses, which are very familiar with, in order to determine what kind of collateral can be actually useful for, say, can be for mitigating credit risk. So the transparency of the system, also the possibility to rely on a very clear, streamlined, centralized registry system would actually allow a sound credit risk management. It would allow essentially to identify possible spot from the banking perspective, from the financial institution perspective, but also from the regulatory perspective. And here I'm now clearly entering more into the key aspect of why it matters, this coordination from a regulatory, from the registry standpoint. Well, let me give you, as I was saying, a couple of examples, actually building on the optimal presentation that has been done before, and in particular to what Gavin was noting. You might recall that actually he was pointing out how the number of registration are particularly useful or can give an indication, as well as the number of search. And so there is a magic ratio that can be somehow, let's say, considered, because as he was noting, and I apologize for repeating in a clumsy way what he said in a much more elegant and straightforward fashion. But the main point is that we do want to have more searches than actually what are the registrations, simply because this indicates what are the that financial institutions have done their due diligence before, let's say, granting a loan and secure with other collateral. So it became quite useful in a number of jurisdictions. when we have been analyzing a mismatch between the number of registration and the number of search to identify what were potential compliance issues that were affecting a given banking sector. I promise I won't make names of bad practices, so I will tell you where these problems have been successfully resolved. So, for instance, in different countries of Latin America, and in particular in Jamaica, the use of the search engine is being actually indicated by the regulators, in that case the central bank, as one of the virtuous practice of risk management. So what we are seeing happening is that the registry becomes a compliance tool, meaning that, of course, not every secure transaction requires registration, and that's stay, and there are other ways to verify enforcement depending on the collateral we are considering. But for those collateral where registration is one of the tools of the mechanism to actually to verify the existence of a priority right, well, actually then we do need to ensure that there is a search. So by presenting the registry as a compliance tool, banks, lending institutions were also forced to think better about their compliance mechanism and to ensure that the credit risk has been properly managed. And, you know, running from one island in the Caribbean to another island in the Pacific region, the same approach has been actually taken by Brunei Dar es Salaam, where actually the idea of using the collateral registry as a mechanism for compliance has been very much favored. This is not over, in a sense that, well, let me clarify one point. To achieve this goal, it is generally necessary that some guidance and guideline have been actually provided by the banking regulator in order to communicate, hey, to check the validity of your collateral, that the fact that you are covered, you need to follow a number of requirements, including verifying in the registry. To move even further these analysis, some central bank has been actually using the data, the collective data that is actually provided in the registry, to actually I wouldn't say to perform a detailed analysis, because that's not the purpose of the registry, and we want to keep it simple, we want to keep it direct, but actually to have an independent source of verification of given information. So, as you know, a central bank might actually have a number of data that is actually coming from reporting and the normal activity or other let's say elements that actually provide for the conduction of stress tests and so on and so forth. The collateral registry turned out to be actually quite useful to have an independent source to verify a number of these data. So if, for instance, the let's say the number of loans that are collateralized they have been claimed in the report actually are not matching or are not close enough to those that are actually in the registry, that might be a very strong signal for macroprudential policies enacted by domestic regulators and central banks. We find particularly very strong interest in this case in Zambia, but the point has been also quite debated also in Mexico, and to see how actually these informations can actually be included in this age where actually technology and data are becoming increasingly important in a clever manner to verify other micro and macroprudential policies, other than actually giving a tool to perform in a much more streamlined fashion on-site and off-site supervision. Finally, there is a general idea when we are looking at how the prudential regulatory system is considering, let's say, collateral. And one of the main points is precisely, well, let's say, we can say that there are two main points that Basel capital requirements are quite stringent and quite clear in order to take a certain kind of collateral as a eligible credit protection. And these are the existence of, well, the certainty of the legal rights, so the enforceability and certainty of legal rights, and the existence of a liquid secondary market. So we understand clearly that actually by having a centralized registry that facilitates the search, allows the supervisor to check, allows the auditors also to have a second look and to validate a number of practices, streamline the policy, well, the credit policy of the bank. It also it qualifies and achieve the first and one of the most important, arguably, point of the Basel standard on capital requirements, which is actually the ensuring the banks have the legal certainty on the collateral. The second point is the existence of a sufficiently liquid secondary markets. And also in this case, we are starting to see very interesting mechanism. Of course, different collateral depending on what we're thinking as a collateral, tangible, intangible, do have actually different secondary markets, and sometimes there are specialized platforms, and that's all fantastic. There are a number of collateral, however, that might not necessarily qualify for, let's say, being registered, being recognized by traditional secondary market platform, even for invoice discounting or this other practice. And those collateral can be meaningfully registered, depending on the situation, depending on the jurisdiction, of course, in the registry. And this is in particular beneficial effect if we think about agricultural finance. This has a very useful application in a number of other areas where actually it might be some doubt on how to create on how to ensure that there is actually a priority right on a given collateral. So in this respect, the creation of the registry, and going back to the prudential regulatory aspect, can facilitate, can increase the transparency, can make sure that a number of collateral of transactions that are not falling into what generally central bank imagine and think as a valid and eligible collateral are also on the spotlight, are also registered, and the right is very clear. So in this respect, we are really actually looking at a point where there is a convergence between the private law aspect, the operational aspect of the registry, and then the regulatory framework. And of course, and I would like to conclude therefore with this note, the scalability of this coordination is fascinating yet to be discovered, in a sense that if we start to add technology and alternative data collection, which is actually already changing the landscape for so-called regtech, and of course fintech and legal tech and all the other declination of legal technology, we can only hope that a centralized, clear, transparent, highly functioning, like a Swiss clock, as Ignacio was mentioning a second ago, is the building block for any future scalability, for any future application, which might come from the industry, from the market, from the usual process of financial innovation, but might also change the approach from a regulatory standpoint in how markets are supervised and what are noticing matching, for instance, what are the percentage of non-performing loans with registration of in the public registry. And this, of course, can only be obtained once these mechanisms are streamlined and very clear. And since I pledged that I will stay in my time, I think I will stop here. But I'm happy to take any questions or comments.
Giuliano, thank you very much for this very interesting presentation. And now I will pass the floor directly to our last but not least guest, who is Professor Alejandro Garro from Columbia University. Please, Alejandro, you have the floor. Thank you.
Afternoon to everybody. My thanks go first to Professor Fabio Rocha Pinto for this invitation, as well as the Ibradim for hosting this seminar. I'm very pleased to be with you today, especially on a federal holiday in Brazil, which is really even a higher mark for the effort that you're making on this law reform efforts, to which we hopefully can contribute at some point. I think that it has been under the Ministry of Economy and the Central Bank that these reform efforts of the unification of the registry system in Brazil has been taking place. I understand that the bill for the amendment of Law 6015 of 1973 is already being discussed, actively discussed. And I think that my remarks are going to be limited and focusing on the challenges of law reform in other jurisdictions and the so-called international standards and best practices that have been inspiring much of these reform efforts. I take it without the benefit of a background on Brazilian law and the Brazilian system. I did appreciate very much the presentation of Dr. Patricia Ferraz and Gianluca Lorenzen about the background on which these reforms have been taking place. My name is Alejandro Garro, and I'm an Argentine lawyer, but my main business is really in the area of teaching and really law reform efforts in areas of comparative law. So I think that what I will try to do is to just focus you on the main aspects of the reform and in other jurisdictions, and to which extent the very basic rule on any comparative exercise, which is to respect and actually adapt to the idiosyncrasies of each country, is going to play inevitably a big and important role in Brazil, as it has played in other countries. In the first place, there has to be, and I think our Gavin, our Australian colleague, already pointed out about the relevance of what he called the awareness of the reform, of the need for a reform, and the commitment on part of stakeholders to the reform. Here we are all professors in this podium, in this panel, but I think that is members of government, Congress, practitioners, academics, as well as the users of the system. The ones who benefit the most, or will benefit the most with a law reform, are the ones who also should be convoked to this type of endeavor. And I think that among the efforts that Brazil is already taking place of changing unifying the registry system, I noticed that there's been effort that Dr. Patricia Ferraz pointed out as a protocolo unificado. It's sort of in a vast country as Brazil, with a federal system divided into 27 autonomous states, how to really harmonize, unify registry practices among federal, state, as well as local government. That is quite a challenge, especially if you have about 5,000 different registers scattered around the country, each one with its own practices that have been going on for many years. Well, I think that the main effort that I see it is to reach at least a registry system that is electronic, unified, and centralized. But the three really touch upon different issues. The electronic one, the technology, of which we, of course, realize that is essential, in my view, is not the most challenging one. It is, of course, extremely important. Without this technology, that would be very difficult to make any other law reform. And I understand that Brazil already has made enormous efforts in automating, moving from a document-based registry to a purely electronic one. But I think that the issue of unified and centralization is more difficult. From an academic legal standpoint, and this may have a ramification in practice, the idea of having a unified system means to have a comprehensive system of all types of security rights in property. And of course, I understand that the movement in Brazil, for various reasons, unlike most other countries, actually encompasses both reform in the immovable as well as the movable registries. So all the real estate registries, as well as the register of titles and documents, as you call it in Brazil, have a very high stake, as well as other registers in the country. That is really quite an amazing, again, effort, especially if you compare with the Australian experience, which is a large country but with much more diminished, reduced population, where we saw through Gavin that without some kind of constitutional delegation of power and intergovernmental among the Commonwealth and the territories and the 6 states of the Australian Federal Union, that change would not be possible. But I do think that here in Brazil, you would need also to have that type of compact among different states under the sponsorship of the federal government to reach really a real genuine reform. The unified system, other than the centralized and electronic, poses, in my view, the most challenges, because we're talking about a system that actually unified the registration of all types of transactions, all of them under this functional concept that is quite revolutionary in many countries, by which any type of obligation or any type of consensual legal transaction that is aimed at creating a security right, a pledge, a fiduciary alienation, whatever you want to call it, a security right in property will be called a security right under the uniform concept, and also and as an all-encompassing comprehensive system where you would have only one registry to actually encompass all these transactions. This is not a small achievement. And I think that it's important is beyond the issue of the abstract legal reform of the civil code and other body of laws in Brazil. What I think our Australian colleague make it very clearly is that the purpose of the reform is to see what is the impact of that law reform in the economy of the system, in fostering the access to credit and reduce cost of credit. And I think this is the more important point that I think can never be overemphasized. The relevance of credit to the operation and the growth of the economy probably does not need to be overemphasized, but I think that probably something needs to be said about the relevance of the legal framework governing security rights in property and access to cheap credit. That I think is not obvious to everybody, but as soon as you realize that the purpose of the reform being actually to make the system more simple, more manageable, actually more suitable and adaptable to modern commercial practices, as we see is the 2009 Australian reform, you will find that it's an enormous connection between the two. The low cost of credit, the free access to credit, not only to those big debtors, but also the small and medium enterprises. That is going to be quite challenging because then, and I think it's crucial to realize that all efforts to reform should be geared to reducing costs and reducing delays. And that will require not only a technology and electronic filing, it also will require substantial law reform. I understand that in Brazil, of course, this would go hand in hand. But in Brazil, you started with the registry reform in the idea that the law of substantive law would probably come someday, either as a standalone statute or as a part of the reforms to the Civil Code of 2002. But I think it's important to see that on this point, it's important to realize that the experience that we have been gathering in this issue is that there are going to be vested interests that are being generally adhering to the past old practices that are going to be inimical or hostile to the reform, and that the reformers should be ready to face a notarial profession, which already has their own way of doing things, a profession of very eminent jurists who are registrars, who are used to filter out and review the legal sufficiency of every document filed for record, and you will see that the international standards actually point to a much more agile, cost-efficient system that probably will do away with much of what notary publics as well as registrars do in the system. But again, nothing of the reform or the so-called best practices or international standards seem to be inimical at all to the legal traditions or to the legal culture of the country. Why? Because the reform actually stands on mainly four different changes, and these, all of them, of course, are under the idea that the purpose of the reform is to simplify, modernize, and reduce the cost of credit. The first one is the idea of, as I already mentioned, about the functional approach, that all consensual secure transaction, no matter if you call it penyor, or you call it alienación fiduciaria, or if you call it a financial lease, whatever name you gave it, as long as the functional economic aim of the transaction is to create a security interest in property, then to that sense, it would have to fall under the same regime, with distinctions being made only if and when necessary under the law. That would definitely simplify much the job and I don't think that that is incompatible with any aspect of the civil law tradition. The fact that the reform was successful in many common law jurisdictions doesn't make it actually inimical or hostile to civil law tradition, because as you can see, in Roman law existed only the idea of very different types of contracts until the Roman legal scholars came out with the idea that there were general aspects of all different types of contracts that you could unify on a general type of contract. Well, that sort of work of synthesis, of unification, conceptual unification, which obviously took many years and centuries of Roman law to achieve, in the area of secure transactions, the civil law countries have not taken the lead. It's the Uniform Commercial Code Article 9, which, after again having under a background of a common law where there were diverse different types of transactions and a multiplicity of registers, since the 1950s and 60s, the United States changed that to this functional system, which again has a unified, all-comprehensive notion of secure transaction. Another aspect of the reform that is definitely not inimical to the civil law standards is the idea that in order to have actually a real right, a right in rem that is actually effective, it has to be erga omnes, it has to be effective against third parties. And the distinction between a right effective inter partes and erga omnes has always been part of the civil law tradition. What has changed is that the erga omnes effect is taking place nowadays, rather than by delivering of possession, by some kind of registration or some kind of more sophisticated type of publicity means, which again is not at all incompatible with the civil law tradition. And therefore, the important distinction to be made and continue to be made in all legal systems is between a transaction that is effective only between the creditor and the debtor, and the one that is effective also against third parties through that registration or delivery of possession. The third and important point to take into account is that registration as an additional step to perfect or make effective against third parties the right in rem, actually is able to establish a fair and effective way of determining priorities. And again, determination of priorities by the time of perfection or by the time of registration is not inimical to the civil law tradition, because the idea of that priori in tempore, potiori in iure, first in time, first in right, goes back to the very roots of Roman law, and is again the same system that is established by more modern systems of priority. Of course, there are exceptions to the first in time, first in right, but the exceptions are carved out in a very detailed and very specifically, and without, again, violating the very basic rule that priority of registration in general would give priority on right. And the fourth element of any legal reform or significant reform has to take into account the question of the enforcement. And again, who would be against the quick, speedy repossession of the of the collateral that is given as a guarantee, and who would be against the idea of allowing the creditor to actually sell the collateral in a private manner, if respecting obviously the rights of the debtor and some commercial reasonableness of standards. And again, I think those four elements, the functional notion of security interest, the effectiveness against third parties, the determination of priorities according to registration, as well as the effective and quick repossession in case of the debtor's default, are all parts of the civil law tradition of which we feel so proud. But what are the, if that is a big picture about structures, what about policies, standards that go beyond the legal structure that we, that very much would depend, again, on the idiosyncrasies of every country. But again, I don't think that the main aspects of a reform should necessarily stumble, because we have seen law reform efforts being made in countries where the record keeping has been exclusively in private hands, other countries where the registration of property interest is exclusively in the hands of the state, and systems like Brazil, where you have the state giving a concession to private companies to run the system. In all of them, however, the functional approach, the centralized system, as opposed to an asset-specified system, is extremely important. One important point of this reform, again, and as having heard the presentation of Dr. Ferraza, it came to my mind immediately when she spoke about the important and relevant role that registrars play in Brazil, is that in order to achieve registration, the law reform efforts uniformly comes up with this idea of notice registry. Notice registry system, which as you will see is part of the Cape Town Convention system, part of the Australian system, and part of almost every other modern system of security. And I understand that in Brazil you already also have shifting from a document system or a title register system to a notice system. What is important is to see the differences between the two. Under a title system like the torrent system that I understand it was in Brazil at some point in force for the land, real estate property, is the status of the title to property, which is actually reflected with a strong presumption of public faith that whatever is in this registry is true. Well, that is not the system that we have and that these international standards are being promoted. Neither is a document system. You don't file for record for registration the whole transaction. You just file for record very basic aspects of the transactions, like the name of the parties, a description of the property, and that very sometimes in some countries the maximum amount of the security obligation, but that's it. No more than that, which has extremely and very important advantages from a delay and cost-effective aspect of that. So I think that in closing, I should just bear in mind that these reform efforts in which Brazil is being engaged would have to, in order to actually result in specific concrete results of avoiding costs, avoiding delays, it would have to be accompanied by some system of awareness of the relation between the credit and the legal framework. It would have to be also accompanied by some system of public education, tutorial guidelines given to lawyers, judges, and students who are going to be living with this new system, and also would have to take into account that we are not alone, because the experience in law reform has been going on for many years, not only in the 1960s in the United States under the UCC Article 9, or under the Personal Property Act in Ontario in Canada, or on the very successful reforms in Australia or New Zealand. But remember that it's not limited to common law countries or developed industrialized countries. The United Kingdom continues to have its own system, and many other systems continue to have their own. Whereas in civil law countries, we have on the one hand the efforts of some of the European Bank of Reconstruction and Development, who in the 1990s came out with the first model law reform on secure transactions, and that has been already adopted by many countries of Eastern and Central Europe. We have the OHADA reform efforts in Africa, and we have, more importantly for us, in Latin America, the Organization of American States, which in 2002 came out with a law reform model that has been already adopted in at least 5 countries of Central America and 2 of South America, Peru and Colombia. And if that would not be all, we do have the UNIDROIT assistance of UNIDROIT with the Cape Town Convention and the MAC protocol, which is already part of the law of Brazil, the Cape Town Convention. So those standards are going to be hopefully transposed, the basic ones, to the registry security rights in general. And we have, so far as the OES model law is concerned, a registry regulation, model regulations that also can help and assist the Brazilian reforms. Last but not the least, the United Nations Commission on International Trade Law, UNCITRAL, has done a lot of work on this area, starting in the 2010 legal guide for the secured interest in immovable property, which is more than a 500 pages document contrasting the different solutions, giving advice to governments how to adopt them. Then there is another legal guide specifically to use secured interest in intellectual property, and as if that would not be enough, years later, UNCITRAL came out with probably the more sophisticated model law that we have, is a UNCITRAL model law on secure transactions, which gives, again, not only very sophisticated assistance, but also is accompanied by a guide of enactment, speaking to legislators who are thinking about adopting the model law. And as if that would not be enough, a guide to practice, which was adopted last year, given to the users of the system to just guide them how to use them. In other words, we don't need to look only to the Uniform Commercial Code in the UCC, to the successful Australian and New Zealand experience or in Canada, but also can look at other countries much more closer to Brazilian legal traditions. Thank you very much.
Thank you very much to Professor Alejandro Garro. That was an amazing explanation, and I was both impressed with your comprehension of Portuguese and also of our civil law and Brazilian legal tradition. So I think your presentation was very precise. Thank you again, everybody. I think that this was a wonderful event for us to be able to learn about international standards. We are starting, as our Secretary Gianluca mentioned in the beginning of this event, we are starting our path towards modernization of registries and towards modernization of our substantive law on security interests. And the existence of the international standards provides us a very good benchmark for us to evaluate how to reform Brazilian law, not exactly adopt international standards straight away without criticism, or even to adopt common law perspectives on secure transactions. As Professor Garro pointed very well, we need to adapt that to our legal culture, and I think adaptation of international standards to a civil law legal country, a legal culture, and to the Brazilian context is very much possible. So that's very good to hear that from you, to hear that from such important international practitioners of secure transactions law, and I think this gives us a very good lesson and actually a head start for our reform in Brazil. So again, I'd like to thank you very much. I'd also like to acknowledge the fact that it is now past 1 a.m. in Canberra, Australia. So Gavin, thank you very much for staying with us until such very, very late hour for you. We really appreciate. Even in Hong Kong now, I think it's already past 10 p.m. So thank you. And I don't know if Ignacio had lunch already in Rome, but if not, he must be very hungry. So thanks very much again. I would like to go straight to our debates. We have a couple of questions, but before we enter the questions, I would like to say that as every reform, and you've pointed very well, we have 5,000 registries in Brazil. We have a particular system of delegation for registrars, and registrars have autonomy and power on the registrations that they make. This is very important, and I think that this is one of the reasons why we have some very, very qualified registrars in Brazil. The fact that registries are so important in Brazil is also a consequence of the legal and constitutional importance that we give to registrars and the high standards of requirements that we have for people to work in the profession of registrars. This is very good for the legal system, but on the other hand, I think that the adoption of international practices may raise some concerns on registrars that are prepared people, and many are scholars, to the fact that they may either lose their roles or lose their importance in evaluating how the registrations are made or how the policies are made. We've had some comments that were not questions here, but comments that express a more conservative view on which approach should be adopted by the reform. And I would like to acknowledge those comments. Unfortunately, we do not have anybody against the reform here in this event. We had sent an invitation to have different views and conflicting views, which I think would be very good for the debate. But unfortunately, nobody against it accepted to participate, but I see that they're watching and that they're sending comments in YouTube also. So I would like to acknowledge that no reform starts with consensus, but I do think that global experience, international practice that we are exposing here today show that consensus is possible at some time. And if world consensus exists, I think it will be much easier to achieve consensus in Brazil once this reform moves forward. So that's the first acknowledgement I would like to make. I would also like to address these concerns and maybe ask some help from our foreign participants on that, because you've had this same kind of experience in other countries. So I think one of the main questions that we have is, when we talk about international standards, we're talking about movable collateral. And Patricia Ferraz mentioned that in her presentation. We have a very unique system for movable collateral in Brazil due to the fact that specific pledges are submitted for registration at the real estate registry. Due to tradition, because, well, as everyone knows, mortgage publicity was the first form of publicity and is in the roots of the foundations of modern publicity and registry, and the existence of real estate registries proved an efficient measure also for publicizing specific pledges in the very beginning. Later on, with the registries of title and documents, generic pledges, more general pledges that were not absorbed into the special pledge definition were submitted to registration in the Registry of Titles and Documents. So the Registry of Titles and Documents is a specialized registry for movable collateral, but we do have this legacy of many kinds of pledges that are dealt with specifically in the law being recorded in the real estate registry. So I think this leads to two questions, and probably is in the root of some concern of, especially with real estate registries right now. I think the first point is, it is very important to emphasize that these international standards, they were thought and they exist for movable collateral. So they are not changing the way that real estate is recorded. They are not removing any power from real estate registries to analyze real estate registrations, mortgages, fiduciary sale of real estate. Everything remains the same from an analysis perspective, from the need of sending documents, and from the way the registry works. So I would like to hear from you a bit of this difference, which is so relevant both to the registrars and to the public. And the other aspect of that is, it has been proposed in the reform that a unified search be also made available for real estate security interests. And that means that whenever somebody accesses the website and requires a search certificate, that search certificate would not only show registrations of movable collateral, but would also contain a list of real property owned by that same individual and the existence of liens or real estate security interests on that property, which I personally think could be useful for purposes of reducing information asymmetry regarding that, but definitely not directly linked to the model law or to UNIDROIT or Cape Town Convention, for instance. So I would like to hear your views on these two topics, which I think are probably elementary for us to start building a consensus on the subject of reform. Maybe somebody can volunteer to speak first.
Sure, if happy to. On the movable property item, I do think, taking off my UNIDROIT hat here, because there's nothing to say about that. We don't work on that area. But well, as an academic, as someone who participated for many years in the work of Ancestral Secure Transactions Group, and who worked with the Spanish registrars, a similar system to the old Brazilian system, I think, to some extent, at least in real estate. I think the principles are very different. I'm aware that there are strong opinions in favor of a system of registration of real immovable property, which is very different to the one of the Latin system. But the Latin system for immovable assets works well if the land is well defined, if it's adequately registered. The system works well. Normally, transactions are worth a higher amount of money, and therefore they justify more some sort of cognitive action by the registrar. So the principles are different, and it makes perhaps sense to differentiate between the two systems. I think that makes sense. And sorry, the second point was on. Perhaps someone else can just take it.
On integrating the search. So obviously the registration mechanism is very different, but
right.
Could we benefit from a unified search? Yeah.
Well, I remember from the times in which Gavin, I was or Giuliano, consultant with the bank or working with the bank. Ultimately, everyone thought it made a lot of sense to have all the information on one borrower clustered in the same registry, so that, or the same database, so that you could, because the whole idea of the registries is to offer, at least part of the idea is to offer a picture and of the situation of the debtor when the debtor is trying to borrow money, so that the creditor can actually gauge true risk of lending to that debtor. So if one stop shop allows for all the information to be accessible by the person who wants to or is considering lending or investing, the better, because it reduces the costs. So I don't see any issues with that.
Some of the responses from Ignacio, if that's okay. Going to the first question, the reform in Australia, for example, and as I think you've highlighted very clearly already, was purely and has been purely about the movable assets reform, reforming and digitizing even, and looking at the real property or the immovable property is much more challenging given the range of complexities that exist and the emotive nature also of dealing with those issues. In terms of the combined search and registration activities, there are a couple of jurisdictions, in fact, that I can think of, but one in particular that springs to mind, who do have already a centralized registry and have created as such of both security interests in movable and immovable property, and that is Ghana in Western Africa, though there are some challenges with the duplication of the registration activity that's required there. So they haven't fully been able to adopt that as a single approach, and there's some detail would need to be considered about that. From a search perspective, in Australia, we've been looking at trying to create a combined search of the nature that you described, where you can look at the mortgage over the immovable property and the security interest from what we have now already as a centralized security interest registry here in Australia. And to date, we haven't been able to do this because of the challenges in being able to integrate with the different search functionality required of the state-based real estate registries, etc. there are some private sector firms who have innovated to fill this gap in the market, and therefore we are now seeing that as a likely, we let private sector take up the running in that regard and can deal with the challenges in doing that, and we don't see the need for us to fill a role as as government in performing that.
Thank you, Gavin. So that was actually very informative, and I didn't know about this initiative in Australia, but definitely I think we would be very happy to know more about that in the future, as Australian real estate registry is very, the Brazilians are fond of it. It has a very long tradition, and it's interesting to know that you are also considering a unified search, which, as I said, and I think you also exposed, is very different from unifying the registration system. We do acknowledge that these are very different in the way they work, but a unified search could be, as you said, an interesting benefit to reduction of informational asymmetry. I would like to actually prioritize questions that were made during Gavin's presentation due to the very late hour in Australia right now. So, Gavin, I think in order to expedite the discussion, I've sent you already in text, but I will read the questions that were made during your presentation, and I would also like to invite the others to step in as they feel that would be good for them to add to the discussion. So there were actually many questions to you as the first participant. One of them is to explain how the business to government interface works in the Australian registry. I understand that for an individual access, an individual would fill in a form in a website in order to obtain a registration, but manually filling a form is not a practical way to submit registrations when you are a big bank or somebody that submits many registrations at the same time. So you mentioned that 80% of your registrations come from business to government interface, and I would like to know how that works, if there is an access point. That's the first question. Also, a second question that is very simple: who fills the registry form? So a little bit of information on that. Third question, if documents are submitted or attached to the registration request. I think that question also comes into the discussion between movable collateral registry and real estate registry. So obviously, for real estate registry, documents are attached. You would send your purchase deed or whatever. But for movable collateral, international practice, it does not require a submission of a document. So I would like to hear also your experience on that in Australia. Fourth question, can you go to the registry in person? If I don't have a computer or access to internet, can I go there and talk to somebody, either to present a registration or to obtain information? The fifth question is there any analysis by the registrar? And again, here, some differentiation between obviously movable collateral and real estate. Real estate will always have analysis. Movable collateral under the international standards, that's where analysis is not required. But again, I would like to hear that from you, if there is analysis and what kind. And last two questions. So first, what is the duration of the registration and why do we need a duration? And the last one is about privacy and data protection. This is a very current discussion in Brazil because our data protection law, which is a lot based on the European data protection law, has just come into effect, and people are concerned on whether that should limit in any way the publicity of registries and how people access, do their searches or access information in the registry. So many questions, but I wanted to put them all together so that you can have more flexibility in your answers. Thank you.
Thank you, Fabio, and thank you to the viewers for those very interesting questions. I'll try to work through them in the order that you gave and do so quickly. In terms of our business to government interface, it is an API, an application programming interface. We're very transparent in how we operate. It's available. You can look on our website and find all of the documentation about how to develop your system to be able to integrate with our system. We can send the links to the participants who might wish to have that information to understand how that can work more fully. We provide the message implementation guides and all the, I can get into some of the technical discussion, though I'm not a technologist, but we can provide all the links and explain how that works. It's available for anybody. So even though you said an individual would not likely create a link using the API, that is true, it's unlikely, but they could. It's available for anybody to do that. We do limit the access until you prove that you can connect effectively without degrading the performance of the system as a whole. So there's a process of validation in there for accessing simply around system performance. Who fills the registry form in? It is the creditor or an agent acting on behalf of the creditor, who is often a lawyer. That's the party that fills the form in. Linking that question with whether there is any analysis by the registrar of the format or the contents of the document. As you alluded to, Fabio, we are speaking about movable collateral security interests only. We are not talking about ownership of any assets. We're also not talking about immovable or real estate as assets. We're talking about the movable collateral only. We have zero analysis. We do perform no process in the function of making the registrations on the registry. The creditor or their agent makes the direct entry, and it's immediately available using the technology. We have no involvement at all. Are documents attached? When we began the Australian regime, because we moved from a significantly paper-based regime, there were significant concerns about the reform and the transition from, in particular, the legal community, the legal from fraternity. So people like you, Fabio, I guess, working in the regime in Australia that existed before our PPSR. So we did actually allow the attachment of documents at the beginning in the first year of the functionality. However, we found that it was very rarely used, even by the lawyers who really loved the paper-based system. It was very, very few documents were ever attached. So after about 1 year, it was actually 16 months after the start of the reform, we cut that functionality off. And since that time, it's not even possible to attach a single document at all. Can you access the registry in person? No, is the simple answer. If you wish to conduct a search and you can't access the internet and the website, for example, you can call our call center, our national call center, and we can help you conduct a search. However, we will not help you conduct a registration. That must be done online or through the API interface. What is the duration of a registration? The overwhelmingly most common registration is up to 7 years. So you can choose a date that is less than 7 years, but the maximum up to 7 years. We then have a second category, which is between 7 and 25 years, and the final category of 25 years plus to an indefinite period. There are different prices for each of those registrations. They are set prices. Up to 7 years, it costs $6 to make the registration. 7 to 25 years, which is not very commonly used, costs $25. These are Australian dollars. And 25 years plus for an indefinite period costs $115. As an interesting side note, to search the registry, it costs $2. Now, one of the significant benefits that I would encourage consideration of is almost an automatic refresh of the database by having a maximum period of registration. The New Zealand regime, for example, has a maximum period of 5 years of the registration. That therefore cleanses the database every 5 years as the maximum. It requires a positive action by the creditor as the secured creditor, secured party, to take an action to extend that registration. That means that they're confirming that the contents are valid and they continue to be so. So that's something which I would encourage within the regime within Brazil to be considered as well. Now, in terms of what privacy protections exist, so there is a strong forceful privacy protection also within Australia, and we also have a privacy regime that is very aligned with what is seen in Europe, and we have had that for many years and are constantly tweaking and enhancing that as well. What we do have is that there is legal recourse written into our Personal Property Securities Act against those who search for grantors as individuals and do not do so for a proper purpose. Now, that's actually a very uncommon inclusion in a law of this nature, of a law of security interests against movable assets. But we've included it because of those privacy protections as necessary. In practice, however, we won't know if that happens. To be clear, there are no protections for anybody who searches against a corporate entity. We're talking about where the grantor isn't listed as an individual. But in practice, unless a complaint is made, we're not likely to ever know that there was a search conducted against potentially my name, and that was for an improper purpose. Now, in terms of abusive filings, that's also a question that we commonly get asked. Now, because it's an open system, anybody can go and make a registration. You can go there now. You can create a log-on account, and you can make a registration after paying a small fee. So is it abused? Well, the answer is that we don't believe so. In the last financial year, remember we had around 2 million registrations in total last financial year. During that period, we found that 79 of those registrations were vexatious, were abusive, 0.004%. We also found that there are only about 54 registrations which should never have been originally made at all, and that is 0.002%, and that's from an open system. And the final question, Fabio, which I think came also through the chat, was also around any measures that we take in the event that somebody wishes to register over the same assets as collateral. And the answer is no. This is a priority system. The first in time to make their registration on the registry will receive the highest ranking. And that's, I think, the simplest answer, which I'll conclude there and happy to answer anything further. Thank you.
Thanks very much, Gavin. And I would like also to invite Patricia and Robson when they like to make their comments and also add some information on the Brazilian system. Patricia, would you like to start?
May I speak, Fabio, please? Thank you. And thank you, Alejandro, Ignacio, Gavin, Giuliano, for your presentations. I've learned a lot about those registry systems and the idea around the movable assets guarantees. I'm very impressed, Gavin, with one aspect of your registry system and implementation of the reform in Australia. That is how you are dealing with the stakeholder engagement. I suppose that it has been working very well because you were in a process of co-designing your system. And since we're here in Brazil with our reform that, as Fabio left very clear, as we don't think about a centralized registry, we think in a centralized access entry and a centralized search on guarantees. I'd like to. I think that we could use these ideas of engaging the stakeholders to co-design our systems. But I'd like to ask you, Gavin, when I went to the PPSR's site, I saw that you, as you mentioned here, that you are a public registry. Have you thought in Australia or is there any idea in Australia on leaving that private companies carry this kind of registry also, or or the registry is totally public in Australia?
Thanks for the question, Patricia. The registry is authorised by law and therefore has the force of state behind it. We are a public institution. We are, sorry, a public agency of the government, an executive agency separate to the government in the way that we operate. However, just to be clear, there's difference between the operation of the registry and the management responsibility for the registry. The registry itself is fully privatised in the way that it operates. We have a private company, Fujitsu Australia Limited, who actually have built and run the technology, and we run the registrar functions and oversee that they perform and deliver the registry to the highest standards possible. So that's the delineation, I guess, in the functions. I think that there does generally need to be the registrar oversight element within government. Though if you look towards Saskatchewan in Canada, it's actually fully privatised, including largely the registrar oversight, with simply a liaison that occurs with the government and in that particular province in Canada. So there are various models around the world as to how it operates in various forms.
Thank you.
Gavin, if I can add to that, I think an interesting discussion that we can have in that is when we talk about registry unification, that is something that we've dealt with in other countries and also in reforms in which we have worked together. You gave the example of Mozambique, and there are other examples of countries that already have registries. Actually, I remember this was a very current discussion at UNCITRAL when the model law was drafted, because the model law itself determines the creation of a unified registry, because it starts from a thought that countries might not have a registry. But in practice, we know that many countries already do have registries, and most of the times it's not one registry, it's registries present in many cities. The case of Brazil, Brazil is a very big country and you have many, many registries. But we've dealt with this before, and I would like to go back to your exposition of the Mozambique case, which I think is very close to what we are suggesting here. I mean, we are keeping all the registries, but we are creating a centralized access platform that would allow people to both submit their registrations of movable collateral through a centralized entry point, and this entry point distributes this to the existing registries, which then remain and keep their competences. And on the other hand, the same centralized platform would provide a centralized search, which obtains information from every single registry in the country and transmits this information, this flow of data, to people conducting searches. So this is, how do you see the solution in view of the international best practice? And I would like maybe to hear some practical opinion from you on how this is being implemented in Mozambique, which is, I think, a good example of how we think this what might also work in Brazil with a centralized platform rather than a centralized registry.
Yeah, look, Fabio, I think you've really probably touched on exactly how it is intended to operate in Mozambique. And just to be clear, the Mozambican regime, the law was passed by their parliament in 2018. The regulations approved for the law in February of this year, and the registry itself is expected to launch in around December of this year. Now, I understand it may be the first Lusophone country that actually launches a centralized registry of this nature. The operating model is, as you largely described, that a registration in Mozambique right now, there are some items which are already registrable, some assets, and there are some that are not. So let's make the distinction between the two. For those where there is no existing registry, you would call those as not registrable. There's a direct entry of the security interest on the central registry, and there's no other process that's involved. Where the existing registrable items come into play and assets come into play, and I'll use the simple example of a motor vehicle as one of those. There's two procedures that can occur. The secured creditor will be able to go directly to the central online using the technology and be able to request that a security interest is made against a particular motor vehicle. That the registry then will direct the information that is required to the conservatory with the competency to confirm and validate the ownership of that asset, in this case a motor vehicle, and they will send back electronically to the central information, whether it's a yes or a no, to be able to then allow that transaction to proceed. Obviously, if it's a no, it will workflow back to the creditor who made the entry for further action. If it's a yes, it will then allow the security interest to be registered at the central, and that's made. And that comes back to that same point that I was mentioning about the importance of the central source of truth, the one valid source where there is the security interest that has been made and the priority right given when that security interest is made. So it's a point in time search. The reality therefore is, and this comes to one of the points that Alejandro made earlier, that the transactional efficiency in terms of improving the efficiency of the process, any delay by the conservatory in concluding their functions under their competency will delay the security interest being registered at the central and therefore impact on the priority time and more importantly, the disbursement of the funds to the beneficiary, to the borrower, which obviously they are trying to receive those funds to be able to do something with those, likely perform a business transaction. And so that being an efficient process is going to be an important aspect of that reform as well. I hope I may have answered the question, Fabio.
Thank you very much. I don't know if Patricia or Robson have any comments on that. Otherwise, I will just follow up with the next questions. So we're about to finish. I have just a couple of final questions here. One of them was directed to Ignacio. The description standard for assets is essential for the search mechanism to work properly. So how do you enforce such description standard and the criteria? And I believe that was part of your presentation, specifically when you were talking about MAC protocol, because there we have a very large number of items that are registrable, and that means that there will be very variable criteria for this description standard, which can also affect the search module. Then there are other two questions that are not directly related to Cape Town, but I think that they provide us some good discussions here. The first one, there is a popular view in Brazil that registry bureaucracy is a typical Iberian and especially Brazilian invention, and I'm sure that you have heard that also as a Spaniard. So as a Secretary General of UNIDRA, you have access to many countries and you do know how registries operate in these countries. So I would like you to address that view. Are registries a local or Iberian phenomenon, or are they a global phenomenon? Can you find registries everywhere, and is bureaucracy inherent to registries? So that is one thing I would like to hear your view. And the final one, is there a standard for describing objects of art? Here, I think, which is a good thing, people are already thinking about new usages for a future registered platform. So I would like to hear your views on that, please. Thank you.
Thank you, Fabio. Thank you to the persons who have asked the questions. On the first one, perhaps the person who made the question was thinking more on the secure transaction model law type of registry, where you have to provide a description of the encumbered asset. Description, you have to define the object to which the secure transactions falls upon. In a general, there is no specific way to do that. It's a very open. When it comes to Cape Town, there is no description of the asset. What you do is just to provide the serial number. The problem is and is going to be a big problem in Mac especially, is that there is no uniform way to provide serial numbers. Well, this is an easy matter. It's easy to identify an aircraft or an airframe. It is not the same, or it is likely not to be the same when it comes to identifying tractors or Mac equipment, because there is no uniformity in the issuance of serial numbers, and the Mac protocol itself talks about additional information to be provided. What this additional information is going to be is still to be defined by the preparatory commission, which is drafting the regulations to the registry. So I'm afraid we don't have an answer to that for the time being. As to the question on the system of registries being an Iberian invention, I would very much doubt that is the case. This type of registries exist basically in a good portion of civil law jurisdictions. This notary registrar system comes from the Latin tradition, which of course incorporates France, especially talking about 19th century systems here, Italy to some extent. Of course, in South America, the influence of Spain and Portugal is very big, but you have to realize that our own codes are themselves very much influenced by the French precedent, especially. Look, I don't think bureaucracy is necessarily linked with this type of Latin registries. For example, the one I know better, the Spanish system, is extremely efficient. The registrars are very, very learned people with very high quality lawyers, and they have a fantastic IT system, which makes it extremely efficient. The problem is not itself in the type of registry, but in the type of activity which is required from the registrar, which is you need to get the documents, you need to analyze the documents, and that takes time. And that is where the difference with notice-based registries really lies. And so it's not that the institution of notice-based registries is better. It's just that they have less work to do, quite frankly. Actually, my own impression, having seen many notice-based registries and in common law jurisdictions, especially in developing countries, and looking at fully developed countries, at least with classic registries, I would say that the bureaucracy and the inefficiency is just as bad in common law systems. So I would tend to disagree with that approach. And finally, concerning the question on works of art, I think the question is not really related to an attempt at increasing the scope. I think the person knows UNIDROIT and is probably asking about the 95 Convention of UNIDROIT on stolen cultural objects and illegally exported cultural assets, which is just together with the UNESCO, the two big conventions in the world that protect stolen art. If that is the question, then the answer is provided for in Article 2 of the Convention, which provides a description of what we understand art objects to be, together with an annex to the Convention. If it's actually asking about works of art for the sake of registration of movable assets, that is definitely not a UNIDROIT specific question. I would think it's just a movable asset, and therefore, generally speaking, it should be. It could be subject to a security interest to the extent that it is not public, and to the extent that the public, if it's catalogued publicly as something which has to belong to the public domain, then there will be restrictions there. But I'm answering a little bit improvising because I don't know what he had in mind or she had in mind.
Thank you. And well, we have a final question here. I think I would submit that to Giuliano, but others, please feel free. That's an interesting question also. What is the role of the registries in view of misguided concessions of credit? And person also gives the example of subprime crisis in the US, which is not also directly related to the kinds of collateral, but I think it's directly related to regulatory overview. So what do you think the role of the registry is for the regulators to oversee concession of credit and to avoid concessions that would not be enoughly secured or covered?
Thank you very much. Well, I would say for the way the conceptualization of registry we have been hearing so far, the role is very indirect, because as we have been at best, because simply that's not the instrument. So the registry is not a regulatory instrument per se, and should not be conceived as such. The registry is designed, as we have learned by this discussion, and also the direction that Brazil is taking, is designed mostly to facilitate the transaction among the parties. And turns out that one of these parties is a bank, let's say, or a financial institution, and therefore is subject to a specific set of requirements. So the registry is a tool, should be conceived as a tool, first and foremost, to achieve the, let's say, the intent of the parties, and allow one of these two parties, well, the creditor in particular, and especially if he's a financial institution, to properly manage risk. Now, these might fit a number, actually should fit a number of regulatory requirements that are asking the same thing. But ultimately, and we can even extend it, put it even broader, what I was saying with my interventions, that ultimately the regulators can look at the aggregate data to have an external, indirect data point to match with other forms. This is a number of advantage methodologically, because if all the data are based on the same entry, well, there is no way of verifying them. So, but beside that, so it's quite important to draw this line, right? In the sense that one thing is cooperation, and using this additional data point, and acknowledging and telling to banks and regulated financial institutions that actually they should use the registry. They should, because it's simply the very definition of sound risk management. The registry cannot be transformed into something else, and then becomes a completely different tool, because then we are back to square one, where actually the parties are not facilitated in their transaction. I hope this clarify, even if it might not be the answer one was hoping for.
Thank you. Thank you very much, Giuliano. So that was the last question that we had here from the viewers. I would actually like to ask again, Patricia and Robson, if they have any comments, and if not, if they can give us some final remarks before we close the event. And thank you all again.
Hi, Fabio. Can I say something now?
Sure, please.
I would like to highlight that improvement of legal security related to movable assets through registration benefits all parties and society in general. For the creditor, there is greater protection, legal priority, and the guarantee of authenticity and effectiveness to third parties. For the debtor and society, the reduction in risks implies lower cost of credit. Registry is not an expandable bureaucracy, but a tool to reduce overall costs, especially if adopted international standards and technology. In addition to expedite the execution of guarantees and increase the effectiveness of rights, registers must also be assigned to carry out other measures which currently depend on the judiciary in Brazil, such as repossession of movable assets, and judicial subpoenas. With the implementation of a national registry web portal covering both movable and unmovable assets, the market will have full access to an ocean of reliable and impartial information that can be used to improve business risk assessment and reduce the cost of credit. So, in my view, technology alongside a registrar is a powerful weapon to assist the development of Brazil and any other country. So, thank you for the attention.
Thank you, Robson. Patrícia, would you like to say some words?
Oi, me desculpa, meu som falhou aqui. Eu queria muito agradecer ao Fábio a realização desse evento, a presença do Alexandre, do Ignacio, do Gavin, do Giuliano, do meu colega Robson, e dizer que assim, é muito importante, quando nós estamos tratando de aperfeiçoamento do sistema, como nós estamos tentando fazer no Brasil, conhecer a variedade de soluções que estão expostas no mundo e como elas funcionam em cada um dos países, né? Eu acho que essa foi a tentativa minha e do Fábio quando nós trouxemos experts em garantias reais e sistemas de registro de garantias reais móveis para essa conversa. O sistema de registro de imóveis, ele tem uma dinâmica diferente porque ele trata de um assunto extremamente caro às pessoas, que é a propriedade imobiliária. Como todos nós, não só dessa sala, mas outras pessoas que podem estar assistindo essa conversa, me perdoem, sabem. O direito imobiliário é por essência, um dos fundamentos econômicos e por isso que existe tanta preocupação a respeito de como levá-lo adiante, como implementá-lo e como aperfeiçoá-lo. Como foi muito bem dito aqui por todos, né? Mas assim, muito especialmente pelo Ignacio, quando a gente se propõe a fazer uma reforma, um aperfeiçoamento, qualquer que seja, por menor que seja no sistema registral, nós precisamos ter uma preocupação muito intensa em fazer esses aperfeiçoamentos, pequenas ou grandes reformas que sejam, respeitando a cultura do país, o sistema legal do país, as idiosincrasias de cada país, porque simplesmente olhar para sistemas que funcionam de determinado modo fora do país que se pretende reformar e trazer essas novidades, esses elementos ou procedimentos externos, pura e simplesmente aqui, por exemplo, para o Brasil, pode não dar certo porque nós temos sistemas diferentes, né? Sistemas legais diferentes, que funcionam de modo diferente, uma estrutura institucional diferente. Basta ver que na Austrália, né, como foi exposto, muitas vezes, se você entrar no sistema do PPSR, você vai ver que determinadas modificações do registro precisam ser feitas judicialmente, porque você tem uma maior agilidade do que se você fazer uma alteração de modo administrativo no registro. E no Brasil, isso, por exemplo, no registro de imóveis, acontece exatamente o contrário. Alterações que eventualmente sejam necessárias serem feitas no registro são muito mais ágeis, muito mais rápidas e baratas, quando feitas diretamente do registro, do que pela via judicial. E a nossa preocupação maior é que o esforço no aperfeiçoamento do sistema não resulte em desassossego, insegurança e muito menos em falta de previsibilidade ou de rompimento ou de depreciação da confiança no registro. e nas garantias em si. O Brasil, não é por acaso, o registro de imóveis tem um patrimônio de reputação importante, porque nós não só registramos garantias imobiliárias e algumas mobiliárias também, mas porque nós promovemos, somos nós que promovemos a execução da garantia real imobiliária mais utilizada no Brasil, que é a alienação fiduciária. Nós fazemos isso com grau de eficiência em termos de rapidez, baixos custos e taxa de recuperação dos créditos incrível. No processo de execução de alienação fiduciária, por exemplo, apenas 5% dos créditos são recebidos por meio do próprio imóvel. O restante, os 95% das execuções feitas no registro de imóveis, são recuperadas em dinheiro, efetivamente, diretamente ou por meio de renegociação da dívida. Então, nós temos um histórico de eficiência muito grande. Eu entendo quando o Fábio pergunta se essa questão de haver um pouco mais de burocracia ou não nos sistemas de registro, não estou falando do sistema brasileiro, mas estou falando dos sistemas de registro de direitos em geral, se isso pode ser uma característica de sistemas legais ou sistemas democráticos. Mas aqui no Brasil, pelo menos, o registro de imóveis se propõe a ser um sistema muito mais simples do que em outros países, mas não menos seguro. E simples no que diz respeito à questão de eficiência e de prazos mais exíguos. Nós já temos, em muitos estados, prazos mais curtos para registro. No estado de São Paulo, por exemplo, um registro eletrônico que venha por meio de um documento eletrônico com dados estruturados, é feito em menos de 5 dias, por exemplo, se o valor do registro for pago antecipadamente. Às vezes a gente demora um pouco mais porque o solicitante do registro demora para fazer o pagamento, mas o nosso prazo de registro é muito exíguo. Se você considera um prazo curto que nós temos, com o grau de segurança que nós oferecemos, isso justifica muito, explica muito o padrão de reputação que nós temos no Brasil, né? Assim, para os nossos companheiros aqui da sala, os nossos companheiros internacionais, eu gostaria até de dizer que o registro de imóveis do Brasil é a instituição, dentre todas as instituições públicas e privadas, a que goza de maior confiança do cidadão. E a nossa intenção é efetivamente continuar a fazer valer essa reputação e essa confiança que a população deposita em nós. E para isso, nós não vamos nos negar a continuar estudando os sistemas paralelos e o que acontece nos outros países, para que nós possamos, como eu disse no início da minha apresentação, coletar ideias e para implementá-las no nosso sistema, de acordo com as idiosincrasias, né, do Brasil, de modo a fornecer um sistema registral cada vez mais eficiente, mais moderno, mais atualizado e mais acessível para a população. Nós temos plena consciência da importância de um registro confiável, seguro e eficiente para o desenvolvimento da economia. Então, eu queria agradecer muitíssimo ao Fábio a realização desse evento, agradecer mais uma vez as contribuições dos nossos colegas internacionais e dizer que nós aqui no Brasil estamos à disposição para novas interações com vocês e para conversas ainda mais profundas, para que a gente tenha a oportunidade de explicar aspectos mais detalhados do nosso sistema registral. Muito obrigada.
Thank you, Patricia. And with that, I think I would like to thank very much our guests for being here today and tonight. Wish you all a very pleasant end of Friday or Saturday for Gavin and Giuliano, and I hope that this is just the beginning of the conversation, and that as our initiatives they develop here in Brazil, we would surely like to count on you and your views and opinions to help us build a better and enhanced system over our currently existing infrastructure. So thank you very much. Thanks for our viewers and everybody, and have a good day.
Thank you all.
Thank you very much.
Thanks, everybody.